Hello, everyone, and welcome to another episode of the Amicable Divorce Network podcast. My name is Tracy Ann Moore Grant, and I am your host. I'm the founder of the Amicable Divorce Network, and in our podcast with Season 2, if you've tuned in, you know that we are going chapter by chapter through our new book, Divorce Amicably, Your Roadmap to Resolution. And today we're going to be covering two chapters, 7 and 8, and I wrote these chapters, and so I invited one of my esteemed colleagues in the Amicable Divorce Network to join me today for this conversation. And so I am joined by Melody Swilling from Swilling Family Law here in Georgia. And she is an attorney, mediator, a guardian ad litem, all of the different things in the family law system, and a member of the Amicable Divorce Network. Melody, thank you for joining me today.
Thank you for having me, Tracy. Looking forward to talking about the different options that are out there to get divorced.
Yeah, I think a lot of times people don't know that they have a choice. They think, I got to run to the courthouse and file the divorce first, and that's the only thing that they really know in regards to a divorce process. And so we're here to share some information that people do have choices, and there's different ways to approach it.
Yeah, I agree. I see a lot on the online community, people giving kind of informal, bad advice, but yeah, informal advice or what I did, or I don't want to use an attorney, because I think there's a fear that, like you said, you have to rush to the courthouse. And that's like killing a mosquito with a nuclear bomb. You don't necessarily need that every single time. It's appropriate for several families and certainly in certain situations, but there may be other ways to do it in a more cost-efficient, emotionally efficient way. And so I think it's just educating as to what path fits you versus what that attorney or your neighbor says is the only option.
Yeah, and not all attorneys practice all the different methods. And so it's sometimes important to meet with more than one, do some research, find out what is best for you and your family, and find a professional that does that type of divorce, because there's actually many different kinds out there, not just litigation. So we're going to talk about first the 3 different ways that people can approach their divorce. And I describe it visually as like the highway. And if you live in Atlanta, you know, this may not apply at all times a day because we generally have gridlock at all times. But if you are sailing through Atlanta, there's generally 3 lanes of traffic, and we have the left lane. And for our UK friends, just flip this. But the left lane is what we call the ludicrous speed lane, where people are going as fast as possible. And I equate that to the DIY divorce or an uncontested divorce. And that is where people are really valuing speed. I want it done as soon as possible. I just want out of this. And they're going so fast that they might be a little reckless. And so sometimes we see that people haven't handled things properly when they do it themselves. Have you seen that?
I see it so many times. There's been times where the parenting plan that they try to present to the judge is, we're just going to agree. Well, You're getting a divorce.
Yeah, so he might not.
You haven't agreed. But I also see it oftentimes is they just don't know what they need to include. And so they're missing child support worksheets, the real estate provision. Maybe they didn't even address that they had a house.
Right. Oh, so my gosh, I've seen that. Or the mortgage. Or the...
Or when the refi is going to happen. It's going to happen.
Yeah.
It's a magic fairy that's going to appear. There's a lot of gaps. Or the provisions are really not practical, right? We see in parenting plans start-stop times missing, rotations of holidays missing. There's just, you don't know what you don't know.
Yeah.
I tell people you could probably go on YouTube and find a way to look up, tooth extraction or dental surgery. We are certainly not doing our own dental work. No,
that's a really good way to put it. That's definitely true. You can get the information. That doesn't mean you should be doing it. I see usually on a weekly basis, whether people, are reaching out to me with just a question or they want to consult, whatever it is, where there is an incorrectable mistake, where people think the paperwork says something, it doesn't. I see a lot where people say like, husband will keep all of his accounts and wife will keep all of her accounts. And it doesn't say what those are, especially with debts. And then they're like, oh, they didn't pay this debt and it's in my name. And it's like, well, you didn't add any of that information.
Well, I say that's kind of like the bare bones, rusty penny version of doing it. While you're going through the negotiations, you might be clear on what you're referring to, really the gold standard. And we have some case law in Georgia, and I'm sure our colleagues in other jurisdictions have similar, it's really not best practice to do that.
Mm-hmm.
I know people feel like it's so tedious to say Bank of America checking account number 1234 with an approximate balance of X on there, but it's really the best practice, and we don't do it because we're just trying to bolster work. It's because we want to protect you in case we all retire. And, 10 years from now, someone's interpreting, did you follow that? Was that clear? And so if everyone retires thinking positively, and we're not there to help give clarity, we're stuck to the document, those four corners. And so,
and you also shouldn't have to reach out to your old divorce attorney to reference their notes for clarity. So I always tell people a stranger at Equifax needs to pick up this document and know that somebody was supposed to pay something. Is that clear?
Well, and that's a good point, because we're getting people going through a lot of mortgage assumptions right now and mortgage refinances, and you want to see someone being tedious. Those mortgage underwriters, there can be clear language that they don't even like.
Yeah,
so
for sure.
You really want to make sure it's clear and that everyone, like you said, a stranger could interpret it. And then we see those DIY uncontesteds have gaps all the time.
All the time. I mean, I've never really seen one that doesn't.
Or the wheels fall off. They want that speedy process. There's no built-in mechanisms. There's no timelines. We may say, hey, please respond in 10 days. Well, by the time you get with your client, they haven't responded in 10 days, then what do you want to do? And then they're like, oh, they were on vacation or they had a work meeting. And I've seen uncontested that people have valid life, like they're ignoring, they're moving on through life, and all of a sudden it's a year later.
Oh, yeah. And nothing has happened.
Nothing's happened.
New set of problems.
Yeah.
So I would say the ludicrous speed lane on the left is your DIY, your uncontested divorce, which means people are handling it themselves. And that is the fastest way, but it's also the way that is most prone to mistake because people are really valuing speed over anything else. And also, it's also our HOV lane in Atlanta. And so you're allowed to have more than one passenger. And so you also have to be together with that person, meaning you're on the same page. We can sit down at the kitchen table and work out all the details. And a lot of times people may not have a contested attitude, but those are just difficult, overwhelming conversations that are really hard for people already going through divorce to navigate.
Well, even with best advice, intake forms and all of that, I find that uncontested conversations that the parties have had have so many gaps in them.
Yeah. They're wrong.
So they're wrong, or I'm having to say, hey, look, I know you guys talked about this, but here's how I've seen it play out for other families. Might you consider this change because you may hate that you did that? And so you're going back and then having to renegotiate or flush out. There's a lot of times they've got bullet points and they just really haven't thought through the rest of it.
Yeah.
So you have to be educated about what your terms are.
Yeah, it's a professional legal experience. So at least have a professional legal person put their eyes and hands on it at a minimum. But, just for the purposes of this illustration, it's DIY uncontested. It's the fast lane. You got to be traveling together, but you're going as fast as possible. So that's most prone to accidents. And then on the opposite side of the highway, we have the slow lane where the grandma is traveling and can barely have her head above the seat. And you're like, who is driving this car? And it's going as fast as possible or as slow as possible. And everybody is honking at it. And that I would call our litigation lane.
Yes. And it seems like with the higher volume that we're experiencing, at least here, it has slowed down dramatically.
Yes, I was in mediation just yesterday, and one of the attorneys commented that they were a little late to our mediation because they were in court to get a court date. The judge was saying, what dates are good with you? And everybody was saying, April 29th, May 2nd. And they were like, no, September, October. And so it takes quite a long time and it costs the most. I know you do contested work. How long are you seeing a case take start to finish that needs a trial?
The ones that are going through trial are taking anywhere from 18 months to 36 months.
Yeah.
And some of that is because we have a county that we all practice in that has judge turnover every 2 years. So that creates its own obstacles and own challenges, of course, because changing of the guard will certainly change our advice. But that's really slowed down. And then we have the issue of you may have a trial calendar week or month or a few that are rolling much longer calendars, but so does everybody else. And you get bumped to the next calendar or you run out of time, or even the judge can't give you the amount of time you need.
Right.
So then you're truncating your presentation.
Yeah, dividing it up and hoping the judge remembers, sometimes across months. You have
I've
the
had
first
that.
part of the hearing 1 month and then the second part 2 months later, and it's hard to keep that momentum. I think people approaching divorce or really anything in family law litigation, they think in their mind that the judge is sitting there waiting to hear their case and they are going to say, come in May 10th at 1 o'clock, and they're going to be sitting there attentive and ready to hear this case. That isn't the reality of how the court system runs. It's actually, if the person before you has gone long, somebody in your case gets food poisoning, there's like all these different things that it has to line up perfectly to actually get to have your hearing.
Well, and I've had a case, it was one of the very long contested cases. The judge couldn't give them 5 days like they asked for, so she gave them 3 days. One was in August, another was in October, and the other was in December. Well, we show up to the August date, and one of the attorneys actually gets sick in the courtroom, has a stomach virus. Wow. So we then had to scramble and find more. So it's just all those unpredictable things. But the courts don't really have the bandwidth to hear all these cases. And so that's one of the frustrations I hear from litigants in highly contested cases, is that they have to wait so long while these issues are pending. They need relief. And the courts just don't have the resources to allocate that time.
Yeah, unfortunately they don't. And then after, like you were saying, somebody had a 5-day case, maybe very legitimately, tons of, witnesses, an expert, but they have to crush that into 3 days. So things are not getting heard. Things are getting left out. People are having to pick and choose. I'm going to call this witness over this one and try to really consolidate this so the judge doesn't cut us off. And people often don't feel like they got heard, like they were understood.
Yeah, contested cases often feel like people think it's going to be a validation. It's going to be a principal argument being validated that they are right. And that, at least in my experience in contested cases, is very rarely the case. You're not going to be vindicated. You're not going to be, the judge saying, oh, you poor thing, come here. That other spouse is so awful. I award you exactly what you want. It's really, they're handcuffed. I often actually say, we talk in hearsay regularly, a day-to-day basis. We use it as a shortcut socially to communicate because it's easy. We talk so differently when we're presenting evidence in court, and that is stressful on the person testifying. It also limits what a court gets to hear. That may be valid reasons why you feel like something is reasonable.
Yeah.
And so
lay people don't really understand the rules of evidence. So sort of a shortcut way is, let's say we have a business valuator, and we'll get to amicable divorce next, but we've used somebody for a business valuation. In an amicable case, we can all have a Zoom with that person, ask questions, look at their documents, see what it is, that gave up to this ultimate value. But when you're in a contested case, that person would have sat for depositions, maybe by each attorney, and then they go to court and you have to submit their report. It's not informal, like, let's just get to the heart of the matter. There's legal procedure and things that have to be done that take more time and more cost. And that's, the formality of the law, which is great in some circumstances, but it really does draw out the time, the cost, and the formality of really just getting to the heart of the matter.
Yeah, and it can be very frustrating. I've seen cases where the one side doesn't present things timely. There's a scheduling order, and so an expert's entire report is excluded, all their exhibits. I mean, it can be very taxing on a party, and then that frustration doesn't entrench a good co-parenting relationship moving forward. Never.
Yeah, never. No. I mean, it's important for people to know the legal process in the United States, England, Canada, wherever you are, is adversarial, which means you are an adversary to the other person. You need to say negative things about them and be, declared the winner of that fact. It's not sort of any sort of cooperative environment. It really is slinging mud, and that's just the way that it is structured.
And I don't know about you, but I have noticed my parties that if we have to have a knockdown, drag out, custody hearing, or even alimony, for instance, where we're having to say very hard things, the worst of the worst about the other party, because we're really just at those odds, invariably there's like an IEP meeting or a parent-teacher conference or school performance the next day. It's just Murphy's Law. Like, they're going to have some togetherness after they've just said how awful the other human is. So that's not great.
Yeah. So I think we've given a pretty good look at the slow lane over there, which is, litigation. And so the middle lane is where people can choose an amicable divorce. Also in this space is collaborative divorce. And I want to note for our listeners, there's an entire separate podcast episode comparing those two, if that's something that you're interested in. But for today's purposes, we're going to talk about amicable. It's the middle lane. It's faster. There's professionally guided, it's customized for the parties, and I've had some that have taken a couple of years because the parties wanted it to. One or two situations with special needs children where the parties had to hit the pause button. We have to focus on this medical issue, whatever it is. How often does the court let you hit the pause button when something happens in life?
Oh, goodness. I've seen it very rarely. Maybe 10% of the cases, someone files a divorce, to just be general, and then they maybe want to talk about reconciling, and I've asked the court, can we put a stay or the pause button on the case? And I've gotten mixed results. Many of the judges don't want those cases clogging up their calendar and their docket, because at least in Georgia, it's kind of Russian roulette of how the clerks assign cases, and it looks like they have a more active docket with more pending contested cases if you do that. So they're not a big fan of it. They're going to push you through. Depending on the personality of the judge, they're really going to say no.
Yeah. And if let's say you have that trial coming up and you're a party and you're like, oh gosh, I have a work trip. My child is ill and I need to stay home. My child is supposed to take this assessment. Or one of your witnesses, one of the witnesses, a key witness was getting married. They had this marriage, this destination wedding set for like a year. And the judge was like,
that's the greatest irony.
Yeah. And the judge was like, I don't care. Then to go forward without them. It's not a very gracious system to flexibility.
No, very rarely is it.
And on the opposite side of that, I've had amicable cases where people really want to speed things up, where they're like, I need some help. We need to exchange some documents, but we got to get this over with for maybe a financial reason, or somebody has to move, or, different things like that. And we do have the ability to accelerate things.
Yeah, I've liked the ability to enter into our own scheduling order. I think that's very helpful. And then so you can set the pacing. You can talk about what the goals are, the issues, because of that attorney conference that happens early, and then assemble the team. Who do we need so everyone has good facts, good data points to talk about the how? Yeah.
Because I think people are often hesitant to get other professionals involved because they're afraid of the cost. But some professionals, like a certified divorce lending professional, for the most part are going to be free. But they can tell us what the mortgage guidelines are so that we don't enter into an agreement that doesn't set somebody up for housing success. Or if we pull in the right professional, you're not paying your attorney to sort of overstep their expertise. They're doing the legal. You call in somebody else to do their job, and it ends up being the same price with better advice from different professionals.
Yeah, I just had that conversation this morning with a client. I have a financial expert, and they were doing some tracing on premarital versus marital assets, but they also put together a balance sheet. And I joked and looked at the client and said, I didn't get an accounting degree.
Yeah.
This was a much better value add. I'm capable of putting things into an Excel format. I really am.
Yeah.
But it's a better value add, and it's very helpful because as a neutral, there's more buy-in a lot of times than a balance sheet or something, a work product of an expert for one side, which is always going to be viewed skeptically by an exiting spouse.
Yeah. And when we are exchanging information, going to mediation, working with other professionals, we can speed that up versus what the court system says. So that's something that people really, I have found, never understand. And in Georgia, we have 6 whole months to do discovery in a case, which is where you gather the information, take the depositions, get the bank records. You can do that for half of a year.
People don't realize how that flies fast as litigators.
Yeah.
But as a party living under it, 6 months can be a lot of life and a lot of changes to go through.
For sure, you could be divorced by then. So with the amicable process, we can still request documentation. We can, get whatever it is that we want, but we can accelerate that and say, can you get me that in 30 days, 45 days? What works for this information? I just did this yesterday in a case, and we agreed on 2 weeks because it was, very limited. Somebody should be able to download from the internet. So also the exchange of information is very customized. Taking the middle lane gives you the best of both worlds. You're still going faster, more customization. Nobody's crashing into you from the left-hand lane, hopefully.
Yeah, I mean, you truly are. You're putting a little bit more control over it. It's like playing bowling with the bumpers up, right?
Yeah.
There's some recourse, there's attorneys on both sides, there's scheduling, there might be experts that we engage, so you're not flying blind. And I find a lot of people are flying blind, whether it's uncontested or even contested, because they just don't know there's other options to tackle this.
Yes, so we always recommend, check it out. See if it's right for you and a fit for your family, and definitely visit a professional to go over the 3 different types of divorce. They can lay out for your particular situation the pros and cons, and they can actually, recommend, yes, actually you need to run to the court right now, let me help you, or, this is actually a pretty common issue a lot of people have, let me tell you how we address it, and have somebody weigh out those choices for you just to get more information and to be more informed. The other thing, I guess the next topic is that regardless of what lane people are in, fast, medium, or slow, every divorce has the same 3 stages, so to speak. I'll just name them off the top and then we can break them down. The first is what is there, gathering the information. Sometimes we spend an incredible amount of time trying to make a list of what do we need to talk about, what is there here. The second stage is assessing that information. Okay, we identified a small business. Do we need it valued? We identified a pension. Do we need to talk about it? Do we need an appraisal? What is going on? And then the third would be pulling those things apart. Either the parties are dividing them up or a judge is, taking a hatchet to them for the parties. So phase 1 is that discovery process we talked about. And some people really struggle with just even being able to identify what they have.
Yeah, that's a common. What we see, at least in my practice, is a high volume of people where one person takes control of the finances and the other person is clueless.
Right, yes.
Whether it's just skill sets or avoidance of other issues, it can be a lot of reasons, but we often have, and you've probably seen this, Tracy, where one person, it's so obvious what the solutions are. Come on, this is all we have.
Yeah.
And the other side's like, I have no clue. I don't know.
Yeah. I've never heard about this asset.
Yes. I don't even know what that asset is or what is it. There's a Roth IRA. How does that differ from my brokerage account? And they're intermingling. And so a lot of times it's educating as well. And that's where I do like having the financial experts involved, because it's 2 voices doing that echo chamber of this is this asset. We have looked at it.
Yeah.
This is accurate. And that can be very helpful for the client that needs education. And
Yeah,
it's not
I
a bad
agree.
thing.
I think that's building trust, so we do see a lot of unknowns. I see exactly the same that you say. Normally in a couple, there's one person that was the money manager and they know where everything is, and the other person has very little understanding of what there is. And so now that they're getting a divorce, the unknowing spouse, you really have to build sort of trust and information with them to say, yes, this is all that there is. That's how much is in here. Here's the history of the account. No withdrawals were taken. This is the tax implications of this. Because until they have that trust and knowledge and confidence, they're not going to be ready to divide anything.
No. And it's also educating the money manager spouse, because it is so obvious to them. They may not have a lot of grace extending to the education of the other spouse. And so I know a lot of our colleagues, we really do work on managing both parties, because those are different tempos.
Yeah.
Very, very different timelines, potentially.
Yeah. And sometimes why can't they just understand that this is all there is? And it's like, well, we really do need to establish and be firm that this is all there is, and, provide some of this
transparency
basis
early on, getting ahead of that so that you build that credibility as you're the exiting spouse, because you don't have it necessarily.
Yeah. Another thing that I see people really skip over, especially if they're trying to do it themselves, is getting values of things. 2 big examples I see are people want to use a Zillow value for their home, and somebody will have a pension, and the other person is like, they have a pension, I don't want to mess with it. Do you see that as well?
I do. I see a lot more, as well as these long-term incentives like RSUs, other deferred comp packages, where the employed spouse receiving those benefits is really protective of them, right? That's going to be one that hurts to touch. And the other party is aware of that, and they're very hesitant to touch it, but it's potentially very large values. And pensions, while they're rare now, those can be quite sizable. I mean, if you have someone who worked at IBM in the 80s, that is
That's
a
a good
good
one.
Coca-Cola before they changed their incentives, right? Like these are big, Cox Communication, right? Like big Atlanta-based companies, but these are big companies that had historically done really great incentive plans.
Yeah.
And if you have a long-term marriage where they've accumulated that, I get not wanting to touch a pension, but you need to know how that interplays with the rest of the puzzle.
Yeah.
It's okay to be hesitant to divide that, right?
Yeah. But at least get the information to know what the deal is.
You have to know, because you don't know what you're giving up. You don't know if you're giving away the farm or that's diminishing returns, not even really worth it.
Yeah, I find people tend to not want to rock the boat. They don't want to spend, just a small amount of extra money to get things professionally valued and assessed. They just want to, cut to the chase. And it's like, I'm not a pension valuation expert, nor am I a real estate appraiser, nor is Zillow technically, so I always advise people just take a moment to have it done correctly, because we will never have the opportunity to readdress this.
Right. Absolutely.
Yeah.
I think there is a little bit of the fear of the bleed out of the divorce cost, right? People are afraid that this is going to just ruin them financially. So they try to find little places to be cheap.
Yeah.
And that's not necessarily it. Spend however many hundreds of dollars on an appraisal.
Yeah. Because it could be thousands of dollars of swing on that appraisal. So I've usually found it definitely pays off.
Yeah, if the expert's fees are covered by the swing, it's still a value add.
Yeah, for sure. So that is what I would call phase 2, which is assessing the information. You have your list, and now in phase 2, every item has a value. And when it comes to kids, of course, there's no value that you can put on that, but there's other information that we assess. Does this child have any special needs that they, can't spend the night with the other parent, or need to be on a particular schedule, or need to transition at practice and not home? Gathering that information as well, including, addiction assessments we do in amicable cases as well. Yeah, we're dealing with it all.
And we have the people that we can refer to help parties talk through and see where they hit snags. I know you and I have done that before. To see, because someone with the lens of the legal aspect, we can translate what the court is expecting to see. But the psychology behind what schedule might work, what parameters might need to be put in place, it's nice to have someone at a much different rate, billing practices, weigh in and help guide parties, again, in that collaborative concept.
Yeah, so usually these professionals are cheaper than your lawyer drafting multiple parenting plans, and can sit down with parties to flesh out the nuances that come with children. So, and
even seeing where the snags are, right?
Exactly. Because sometimes that's where parties get hung up. Sometimes it's over something we would consider legally minor, like who's going to keep the passport, but maybe that's actually seated in a much bigger issue that somebody else can dive into and work with the parties on.
Agreed.
So we got through phase 1. We have our full list of items. We got through phase 2. We have all the information that we need. And then we get to phase 3 of a case, which is pulling it all apart. Now we're making 2 lists. We're making a parenting plan, and there's a couple of ways to go about this. One is the parties can figure it out themselves if they're in the ludicrous speed lane, or as much as they can, even in an amicable or a contested case. Maybe you can knock a couple things off there. Another way is mediation. How successful do you find mediation to be in resolving disputes?
So I think every mediation that parties show up with a good faith effort to knock out as much as they can that day is actually successful.
Yeah.
It's just whether you're writing a memorandum or a settlement agreement, parenting plan at the end of the day, or having more action items. Maybe you identified gaps in the perceptions. I know we have a county where we have to mediate before we get a court date. Yeah. So we're often mediating perhaps a little too soon in many cases.
Yeah.
But it can identify those friction points, so that maybe a second mediation would be fruitful. So I always preface it, most mediations are going to be productive just by the fact that you showed up and you're willing to talk. I'd say a high percent. I don't keep data on it purposefully, right? Because you
don't want to psych yourself out.
Well, and also the parties are in the driver's seat at mediation. They're in control. They can craft it more specifically. So I think that if they're coming to the table that day, it may be a marathon day for how we do it here, or multiple days as our colleagues elsewhere do, but a high percentage settle.
Mm-hmm.
Or something's percolating as they leave that day and their attorney is able to talk to them about a proposal after mediation. I'd say 95% of cases settle before they get to the courthouse steps.
And that's statistically true. So you nailed that right on the head. But yeah, whether it's through mediation or future negotiation, and mediation, I would say I agree with you, is almost always productive. I have very rarely in my entire career had one of those mediations where I walk in and they say, this is our first and final offer, and the other party doesn't accept it and everybody leaves. I mean, maybe twice, 23 years for me, have I ever seen that happen. But for the most part, people are making agreements on some issues or all issues, or having productive conversations, or the attorneys are identifying, oh, this is a problem and we need to go back to the assessment stage and get that valued or get more information so we can then come back to the settlement stage. So it's almost always a move forward, several steps ahead towards settlement in one way or another. If the parties can't agree, and if they are in that unfortunate 5%, then the judge pulls it apart for them.
Yeah, what a way to gamble with your kids' lives.
Yeah, and everything, your finances. I think it doesn't mean that an attorney has done anything wrong when their client doesn't get everything that they wanted walking into court. I think even the best litigator walks away with the judge having sort of split the baby, I hate to say, so to speak, but usually everybody's going to get a little bit of what they want.
Yeah, I mean, and I know we can have a general range of, here's how I've seen this judge resolve this issue or similar issues in the past. That judge can walk in that day and just get it wrong.
Or not walk in at all, and you have a substitute that day.
We love that. We have a county where you never know which judge is showing up. But also, they may just hear the evidence differently, and they may not like how your client's body language was. There's a lot of psychological issues going on in the courtroom, how you present. Are your witnesses likable, credible? Do you have a weird twitch that is driving the court crazy? I mean, they're human.
Yeah.
And what did the case before you with similar facts do to, piss them off, right?
Yeah, exactly. I had a judge one time say they were making their decision based on an episode of 60 Minutes that they had watched the evening prior. They wanted to try. Yeah. So I was like, oh, that's amazing. Yes. Let's please be the test case for the 60 Minutes episode.
Yeah. Well, and depending on the jurisdiction, how much leeway does your judge have? Is it any evidence to support them and it gets rubber stamped? That's a really broad leeway for a judge to say, this is just where I land, sorry.
Yeah, exactly. I mean, I think when people are deciding through mediation, negotiation, their settlement themselves, they're going to compromise. They're not going to get everything that they want. That's very similar to the court action, but they're in control. They can be more creative. The judge is not going to be too creative with a parenting plan. They literally have a book of parenting plans that sit on their desk. They're going to pick one out for your family, whether that involves your family traditions and that 4th of July picnic your whole family goes to every year or not. Maybe, probably not. They're not going to have heard testimony about that.
Yeah, or worse, the judge is one that is slow to sign orders. Yeah. And so you have a full hearing.
And then you're waiting 9 months.
Yes, to get a rubber stamped cookie cutter order. Yeah. And I will say we do have judges that listen to the experts. And I was a guardian recently, and one was very, very crafted to the testimony and the evidence presented. But it took 3 months for that order to come out. And the parties were in limbo for that entire period.
Yeah.
And it's a gamble.
Yeah, it's a gamble. People are deciding when they go to court that it's better for a stranger, the judge, to their family to hear the absolute cherry-picked facts on the timeline that the court has and hope that that is the best result for their family. And it rarely, if ever, is. So as much as people can be in the driver's seat, much better for them.
Well, and frankly, the judges are going to forget your kiddo's name. They're looking at pleadings, and they'll say, well, what about little Johnny? We all say, that's fantastic, but the kid's name is Jimmy. Yeah. And that tells you everything you need to know.
Yeah, that's exactly right. They just don't have the bandwidth to really get into knowing about every single family.
And we have judges that, not a knock on them, like they're working hard. It's a hard job, the volume they have. They just can't, with that volume, give it the attention you as litigants can to be personalized.
I talked with a judge last year. I think we had this conversation, and he said he's always baffled when people are like, we want you to make decisions about our family, because he's like, the parties know the most. The lawyers assisting them and their professionals know the second most, and I know the least. He's like, so it always is surprising. I'm like, me?
I think that goes a little bit to our adversarial system, is that the judge is not doing an independent investigation.
Right.
They may have experts that they appoint to help them, but if that expert can't testify to certain things because of the rules or just doesn't interpret the investigation the way the court had hoped it or the parties had hoped, that judge's information, that lens is a very narrow filter.
Yeah, it's a spotlight and everything else is in the shade. Yeah, you're touched on it. We have an adversarial system. Other countries do have an inquisitorial system where the goal is to find the truth and the judges ask questions. We don't have that. We don't have that in the United States, the United Kingdom, or Canada. So it is very much throwing up your best stuff and seeing what sticks and hoping for the best. Melody, thank you so much for joining me here today for this conversation. If people are listening and they want to reach out to you and work with you, where can they find you?
Yeah, they can go to www.swillingfamilylaw.com. We are at Instagram at Swilling Family Law, or they can call us at 6.
And Melody is in the metro Atlanta area helping parties with all things family law. And so if you're driving and you're like, oh my gosh, I can't write down that information, just save this episode and it's in the show notes. Make sure that you give us a 5-star review and hit the subscribe button so that you get to go on our journey of all of the chapters of our book, Divorce Amicably, Your Roadmap to Resolution. Melody, thank you again. I really appreciate it.
Thanks, Tracy.